Dear students, this is the third class for BUS202. We have already finished the first two classes and the preliminary discussion about the course itself and how a contract is created, about the offer and acceptance. These are all finished. So you will remember that in our initial discussion, we did discuss about certain essential element of a contract. I did share with you that there must be an offer by the offerer, the offer must be accepted by the offeree, and there will be exchange of consideration coming from the offeree to the offerer. So these are the very three important essential elements of a contract. But then again, there are other essential elements, failing which the contract will not be a binding one. So there are 5 essential elements of a contract. If you remember, let me remind you again. The agreement entered into must be with free consent of both the parties, offerer and offeree. They must give their consent freely without any pressure, coercion, undue influence or whatever may be, number one. Number two, the parties to the contract, I mean the offerer and the offeree, they must be competent to contract. We did discuss a little bit in our last class about all those things. The third one, there must be consideration coming from the offeree to the offerer, because on what basis the offeree accept the offer? He must do something, pay something, or suffer something for the offer. Otherwise, how acceptance will be there? The fourth one is the object of the contract. The object of the contract must be also lawful. Without having a lawful purpose or object, any contract entered into will be void in the eye of law. And the last one, the Contract Act 1872 categorically mentioned that there are 5 different situations where you cannot make a contract. Even if the parties intends to or enter into a contract, that contract will not be acceptable in law. They will be known as void contracts. We'll go them slowly. So let us talk about the first essential element, that the parties to the contract must give their consent freely. Their consent must be free. There cannot be any pressure, coercion or whatever may be. And that's why today's topic is vitiating element of a contract. The presence of which factor may vitiate a contract, may destroy a contract. There are in fact as many as 5. Coercion, undue influence, fraud, misrepresentation. These 4 factors, presence of any one of them, not all of them is necessary, presence of any one of them, presence will make the contract vitiated, will destroy the contract. The contract will be considered as void. Despite the fact that there is a contract, the offer was given, offer was accepted, and well, even after the making of a contract, even after some time, if one of the party considers that his consent was not free, there was coercion from the other side, or if he understands afterwards that he is a victim of undue influence, or he realizes that the other party made a fraud with him, fraudulent activities were found, and he finds this afterwards, even after the making of a contract, doesn't matter. He can always go to the court, and before the court, if he can establish that any of the 4 factors were present in the negotiation process of a contract, he can ask the court to declare the contract as void. So you must keep in your mind that an apparent agreement, signing of a contract and everything, actually is not the contract. That particular contract must essentially satisfy the 5 different elements, of which today we are talking about the first one, the vitiating element of a contract. As I already told you that there are 4 factors. Number 1 is coercion. Coercion is a situation where one of the party uses force or pressure upon the other party to obtain the consent of that party, to bring that party in the contract, in the negotiation process, to win over in the negotiation process. So it is a pressure, duress, or whatever may be. That is what is called coercion. And in my first class, I told you that in coercion, some force is being allowed. Now, so far, the Contract Act 1872 is concerned. Section 15 of the Contract Act 1872 specifically relate to coercion. And Section 15 of the Contract Act 1872 prescribes coercion is the committing or threatening to commit any act forbidden by the penal code. Now you may say, sir, what is penal code? I have no idea. Yes, very true. You are a business student just doing the law of contract as a subject within the business law. For your information, just to know that penal code is a law that contains all the crime. If you commit anything within the penal code, then that amounts to a crime. So it's contain only the crime. So it defines what is murder, what is kidnapping, what is fraud, what is misrepresentation, and all different types of criminal activities have been defined under the penal code, and they were made as crime and punished by the sovereign of a country. So Section 15 suggests that coercion is committing or threatening to commit. That means to commit anything, any act, to do any act which is prohibited by the penal code. Penal code says that if you do any of this under the penal code, then you commit a crime. So any act which is forbidden or prohibited by the penal code, committing of that will amount to a coercion from one party against the other. This may take in the form of, as I told you, some sort of pressure, some sort of duress, threatening or something like that to make me come into the contract. But then again, what about threatening to commit? As a matter of fact, he has done nothing, but he just has made a threat. He has not committed any coercion. One is committing. He forced you. He grabbed you, tied you up, and then signed this contract. That is, he's using his force to get your consent. The other one, the next part of the section, as a matter of fact, is not really doing anything, but only threatening. Even threatening to commit an offense which is forbidden by the penal code is also a coercion. For example, you have a business official, government official maybe, is not allowing a businessman to have a particular clearance from the government to pass his bill. Suppose he is a contractor. And he was asking for the passing of the bill to get the money. The officer is a very honest officer, and he said that these are the certain documents that you must bring, failing which I cannot allow your bill to be passed. So he went after the office here and there and tried to bribe that gentleman or tried to have it. Eventually he went to the officer and explained him that these papers are no more with me, I have lost them or something like that. I am ready to pay the expenses towards the office, the speed money, the speed money he is ready to pay. Sorry, just please allow this bill. Then the gentleman is an honest man. He became very angry and say, if you utter this thing anymore, I will have to inform the police. So immediately he left the office. He went home Day after or so like that, he called up in telephone and said, am I talking to Mr. Chaudhary or something like that? And he said, yes. And he gave his identification and say, I am that particular person. If you do not pass my bill, if you do not sign the file by today, I know everything. The color of your car is red, the number of your car is blah, blah, blah. And your daughter studies in Agroni Balika Vidyalaya. You understand, he just laughed and kept the telephone. Rest is not said, but it is understood. What he came to know that this gentleman is threatening him to kidnap the daughter if he doesn't sign. So this is what, when a threatening or a threat may be considered as a coercion. So coercion is a factor that will destroy a contract. Presence of coercion will destroy a contract. But then again, how? Suppose a contract is made. This is a good contract till it is been declared void. When coercion is there, that contract will be considered as a voidable contract. Not void, not bad, voidable. That means it can be made void by one of the party going to the court, asking the court of law to declare the contract as void because he can claim that my consent is not free because there was coercion. Any of the four factors, coercion, undue influence, fraud, misrepresentation, any of the four will make the contract void from voidable. So this is what is coercion is. You have to understand what is coercion and how you can go to the court, before the court, and ask the court, and if you can prove that yes, the other party used force and duress to have your consent, so he has done something which is prohibited by the penal code, then the contract will become void. And few things which you will get in my the notes that I have given for my lectures, it will be loaded there. It's there. A threat to prosecute a man to file a suit against him does not constitute coercion, because it is not forbidden by the penal code. That is the catch. If not forbidden by the penal code, that is not coercion. Supposing a bank is charging a good amount as interest, and without just giving a notice, within a year he enhanced the interest, asking for more interest from the borrower. Is it coercion? No, it is not coercion, because asking more interest as a banker is not prohibited by the penal code. It is between the party and the bank to decide. So these things, these are the decision of the court. There were cases before the court and it was decided. It is also not coercion to charge high price or a high interest rate. A threat to commit suicide, the question may come. A threat to commit suicide, whether it is considered as a coercion or not. And there is a famous case, you will find it in my precise note under coercion. It was a case of Madras High Court. The facts was like that. A girl from a Hindu family decided that he will fast to death and ask his father, if you want to marry me this boy, you have to give a 2-storied building to me, failing which I will commit suicide. Now the father has made a gift to the daughter. Daughter got married and everything fine. But within 3 months, the mother of the girl died. And accordingly, the father and the brothers, they went to the court and say there was a coercion. So question came up with threat to commit suicide is a coercion or not. And on that issue, it was decided by the Madras court by majority decision that threat to commit coercion, a threat to commit suicide is a coercion under the Contract Act 1872. So in the next segments of the deliberation, we will talk about the others, undue influence, fraud and other things. Thank you.